Donald Trump files a motion to halt the January 6th case to put a stay on Jack Smith's prosecution. It's taking place out of Judge Chutkan's courtroom. We know trial is scheduled for March, the day before Super Tuesday. And we also know that Judge Chutkan has issued orders denying Trump's motions to dismiss. He's already filed several of these. One for a motion to dismiss based on constitutional grounds, saying Trump had free speech on January 6th and nothing in the indictment is violating the law, and said that there were other bases for why the case needed to go away. Now, the judge denied that, and so Trump has issued an appeal, which is this document. It's the notice of appeal on the motion to dismiss. We'll look at it, very short, but the more substantive filing, the one that's going to cause Jack Smith and everybody to be in a little bit of a tiff on this, is the motion to stay the entire case. Because if the Court of Appeals rules in favor of Trump on this constitutional basis and the whole case is dismissed, then it's gone, right? Trump wins and it's done because the violations were so egregious. But that means the trial doesn't go. And if the Court of Appeals comes and takes this away from Chutkan, then all their eggs essentially are in this basket. They got to get this trial to start in March, and they're working hard to make that happen. So Trump is asking for a stay, and what happens if the Court of Appeals grants it? They're not going to be happy about it. So we're going to go through both those filings and then see what Jake Tapper says about the J6 case and the 404B motion, which is the character evidence motion that we talked about here earlier in the week when the government submitted that. But briefly, this is the order that was the notice of appeal that was submitted out of the Washington, D.C. court. You see, out of the United States District Court, it's just a simple one-page filing. It is the notice of an appeal. It is not the actual appellate memo, the memorandum, or the brief. It's just a notice. And so all they're saying is, guess what? Your Honors, President Trump is here providing notice that he appeals to the United States Court of Appeals for D.C. the memo, opinion, and the order, both of which we covered here previously. And you can check out our January 6th playlist if you want to catch all of the Trump January 6th prosecution playlist, if you want to catch all of the videos for that. So it said that these motions, these orders are now being appealed, signed by John Lauro and Todd Blanche. And there's a sequence that is happening here that we're observing. Okay, Trump has to make these things anchored in before and rejected, okay, because Chutkan is going to reject this current motion. This is the notice of appeal, but filed simultaneously with that is this document. This is President Trump's opposed motion to stay the proceedings pending the appeal. So while he filed that one, he's saying, Your Honor, we're going to be appealing this thing, so we got to stop this case. Jack Smith is already opposing this, obviously. They want this trial to go because this is their big one. If they can get Trump convicted of a felony, they're going to splatter that all over the place. A felon! The Republicans nominated a felon. Can you imagine that and where this is going? And they're going to do the Chris Christie line. He's not even going to be able to vote for himself. You know, that type of stuff, which will be true. And maybe they'll try to imprison him, like no joke. Maybe they'll try to lock him up somehow. Now, I'm really doubtful about that because he is the president. Can't imagine the Secret Service would do that. And I don't think America would stand for that, quite frankly. If they say Trump's going to jail, I don't know how that would work out for him, but we'll see. And of course, we're always encouraging everybody to stay absolutely peaceful and patriotic. But we understand that certain things might get a little bit, heated if they say, we're going to be imprisoning Donald Trump, which they would love to do. Don't get me wrong. So this is Jack Smith opposing this because they need to keep this in queue. So Trump is respectfully submitting this motion. Chutkan will deny it. Then Trump will appeal this one. Then the Court of Appeals might be able to actually stay the proceedings. Say, hey, we're going to grant an interim stay on this or an administrative stay on this. So we're just following the bouncing ball. So here is Trump's defense. They say, all right, we're submitting this motion for an order enforcing the automatic stay of all the district court proceedings in this case. This is Chutkan's courtroom. In this case, pending the final resolution of the recently filed appeal from the court's December 1st ruling based on presidential immunity and double jeopardy, constitutional arguments and presidential immunity. Now, the filing of President Trump's notice of appeal has deprived this court of jurisdiction, which is pretty bold, right? Saying, hey, Chutkan, you don't even have the authority over this case anymore. When we filed this document, this notice of appeal, it's not yours anymore. It's going to the Court of Appeals. Jurisdiction over this case in its entirety. Court is gone, pending the resolution of this appeal. Sorry, Judge Chutkan. Do you think she's happy about that when she's reading this right now in her chambers? No, not at all. So therefore, Trump's defense says a stay of all further proceedings is mandatory and automatic. Sorry, Judge, whether you like it or not. They're going to explain it. They say, moreover, last week in another case called Blassingame versus Trump, which is something that was situated out of the D.C. Circuit Court, which we read here. This was the immunity case. The D.C. Circuit made clear that official immunity issues must be resolved prior to litigation and discovery on the merits. And that was on a civil case where the people are suing Trump. Congress people and the various Capitol Hill police are suing Trump. We also talked about that one because the court basically said that Trump can be sued, or that the case is not going to be dismissed at this stage, that it's going to proceed to the next status. We made a video about that one. So they say, thus, in addition to the lack of jurisdiction here, sorry, Chutkan, you don't have jurisdiction. Blassingame, which also came out of the D.C. Circuit, which is Judge Chutkan's courtroom, requires the court to stay all proceedings, saying your own court made a similar finding in a parallel case against this defendant. So you have to stay all proceedings in this matter pending appeal, including but not limited to all this stops, right? We're done. Pretrial motions, defense disclosures related to trial defenses, any evidence, SIPA hearings, jury selection, all of it is now paused. Now, as a result of these authorities, all current deadlines must be held in abeyance until at minimum this motion is resolved. Now, President Trump will proceed based on that understanding and the authorities set forth herein, absent further order of the court. Woo! That's some good motion there. Okay. In other words, Judge, we think this is the interpretation of the law. Once we file our notice of appeal, it goes up to the Court of Appeals. Your jurisdiction is now set aside, and we now move up to the Court of Appeals. We're going to be going this direction unless you tell us differently. Now, they're baiting the judge right now, right? When you see that, absent further order of the court, it's going to happen is Judge Chutkan is going to come back out and issue a further order. Okay. She's basically going to have to. And she's going to say, no, my position is the position of this court. And here she's going to say that this date is confirmed, and this date is confirmed, and this date is confirmed. And that's going to cause Trump to then take that appeal that, and ask for an administrative stay of those dates to move those dates around. So here is what Trump's defense says. All right, Judge Chutkan. On October 5th, President Trump filed a motion to dismiss the indictment on grounds of presidential immunity. Now, then on October 23rd, Trump filed another motion to dismiss the indictment on constitutional grounds based on double jeopardy and the impeachment judgment clause. We've covered both those motions here. Now, on December 1st, the court issued a memo opinion and an order denying both of those motions. The court incorrectly denied Trump's claim of presidential immunity on the grounds that such immunity does not extend to criminal prosecution for a president's official acts. And the court also denied Trump's double jeopardy claim on the ground that neither traditional double jeopardy principles nor the impeachment judgment clause provide that prosecution following impeachment acquittal violates double jeopardy. And we read through that in detail. Now, their argument here, now Trump says, okay, well, we got those orders on December 7th, which is today. President Trump filed a timely notice of appeal of this decision, and we read that notice. So here's the argument. They say, all right, Judge Chutkan, this is the deal. You're out of jurisdiction. You don't have any ability to control this any further. It says the Coinbase and Blassingame decisions illustrate that proceedings in this court must be stayed pending the resolution of President Trump's appeal of the court's order denying his motion. Okay, Trump said, I'm immune from this. There is double jeopardy here, and said that, yeah, double jeopardy here because he's being prosecuted after he was already acquitted. Okay, he was acquitted in the Senate on January 6th, and now he's being prosecuted again. So this stay is jurisdictional. It's not discretionary, Judge Chutkan. It's mandatory and it's automatic. So you're done. You're done. And judges don't like that. Now, he didn't say you're done, but that's what he's saying. Now, in Coinbase, the Supreme Court considered whether an interlocutory appeal, so meaning an appeal in the middle of a case, for most criminal cases as a standard rule, the appeals come at the end because you don't have a bunch of other ancillary collateral consequences in the middle of a criminal trial. For example, you don't have presidential immunity claims in most criminal cases because you don't have presidents ever being charged unless you have Democrats who are running the country and prosecuting their political opponents as they are here. So here, what is, the Supreme Court asked a question, can you appeal in the middle of a case? The Supreme Court held whether there's an automatic stay of proceedings when an interlocutory appeal is in place. The Supreme Court said that it does. There is an automatic stay. The sole question here is whether the district court must stay its pretrial and trial proceedings while the interlocutory appeal is ongoing. The Supreme Court said that the answer is yes. The district court must stay its proceedings. Now, in that case, Coinbase, who won the argument, they said the automatic stay is just a straightforward application of long-standing principles. If you're appealing in the middle of a case, it makes sense to pause the underlying event. It requires an automatic stay of the proceedings that relate to any aspect of the case that's involved in the appeal. So in that case, applied to a motion to compel arbitration, the Supreme Court held that the entire case, if the entire case is essentially involved in the appeal, then you got to pause everything. And therefore, the entire case must be stayed. Like, can you only appeal a portion of it and then deal with it later and then send that back down and then integrate it back in? Yes, but not here. If the entire case is enveloped in it, you got to pause the whole thing. This is because the key question in that case was whether the case belongs in arbitration or instead in district court, right? Major question. They're not asking about a small evidentiary question, which you can save to the end of the case, but they're asking, like, literally, what court are we supposed to be in? Is it supposed to be arbitration or is it supposed to be a district court? The exact same true holds here. This is a major question. They say, Your Honor, President Trump has appealed the court's rulings on his motion to dismiss based on presidential immunity and principles of double jeopardy. Both issues concern whether this case can be brought at all, okay? It means the entire case is essentially involved in the appeal, because if he wins on double jeopardy, it's all gone. If he wins on presidential immunity, same thing. They say presidential immunity is immunity from suit, not just immunity from liability, okay? And this is another important distinction as well. Having immunity doesn't just mean that you get to like deal with a bunch of nonsense lawsuits, okay? Because the process is the punishment. By suing you, by prosecuting you, you've got to take time, money, resources, energy to go respond to those things. And so you're immune from even the suit so that you're not out of anything. So when a party appeals, they say, the denial of a motion to dismiss based on official immunity, the question, quoting from a U.S. Supreme Court case called Coinbase, the question when there's a motion to dismiss based on Trump's immunity is whether the litigation may go forward in the district court is precisely what the Court of Appeals must decide. Here, as elsewhere, it makes no sense for the trial to go forward while the Court of Appeals cogitates on whether there should even be a trial in the first place. And so Coinbase explicitly recognizes this conclusion. It cites appeals of official immunity and double jeopardy as uncontroversial circumstances where automatic stay of proceedings is required. In other words, Coinbase in the Supreme Court, this is a great case for them, is recognizing this, saying in the circuits that have considered the issue in the analogous contexts of qualified immunity and double jeopardy, when you have qualified immunity, other immunity, not presidential immunity, but like for police or for other politicians, and when you're considering double jeopardy, district courts likewise must automatically stay their proceedings while the interlocutory appeal is ongoing. They emphasize this. Automatically. And qualified immunity and double jeopardy were the two types of motions that Trump's defense submitted. Probably by design. They found this Coinbase case and like, perfect. So Coinbase, hey, here, boom, boom, and SCOTUS. Now, Coinbase is going to be a civil case, right? That's the crypto exchange, but it's a civil case, but they're referencing why an automatic stay is appropriate, and they're referencing other case law that was incorporated into the Supreme Court case. So official immunity and double jeopardy, of course, are issues at stake in President Trump's interlocutory appeal. And so, this might be, my friends, like four-dimensional chess, all right, is what you're seeing. So they actually submitted their motions in this manner, okay, and they wrapped both of those issues up basically into one. They were waiting for Chutkan to deny it. Then they're submitting this one, knowing that SCOTUS has already given them this foundation with the Coinbase case. It's quite good. So then they just got this one that just got ruled in their favor. So then in Blossingame, which is another case that's bad for Trump because it says that the Capitol Hill police cases can go against him, can move forward to the next discovery phase. Trump filed a motion to dismiss. They said no, discovery is allowed, and so it can move forward. So they said, okay, well, the DC court literally just came out and reinforced the rationales that require a stay. Now, the Court of Appeals held that factual questions related to Trump's presidential immunity must be resolved before any merits-related discovery. That's their words, Judge, not ours. So we have to pause the case before we can go to actual discovery. That is because official immunity, including the presidential official immunity, is immunity from suit rather than a mere defense to liability. Official immunity is so powerful and so broad that it's literally an entitlement to not stand trial and face other burdens of litigation. We protect them so hard. The official claiming immunity from suit is the president. These concerns are particularly pronounced. Thus, the court held that President Trump must therefore be afforded an opportunity to resolve his immunity claim before merits discovery. Before you can start opening up the floodgates, you got to make sure that he's not immune. So Blossingame, which does say that, the case can move forward to investigate this stuff, reinforces both that the entire case is involved in an appeal related to official immunity and that the stay must extend to all cases. cases, saying it's another companion case that's very similar. So here, Your Honor, Chutkan, sorry, but the law says the following: Coinbase, Blossingame, and DeFries, they unequivocally support three conclusions here. One, the stay of the district court proceedings is mandatory. Sorry, Judge, you don't have an option. It is not discretionary. And two, the stay applies in criminal as well as civil cases. So even though some of their cases like Coinbase are civil, we're talking about criminal because it's the same feature. These are defense principles, right? It's just logic. If the entire case is in question, you have to pause the entire case. And the stay extends not just to the trial, but to the pretrial proceedings as well. And Coinbase held that Griggs, which is another case, it dictates. They say you have no option. The district court must stay its proceedings while the interlocutory appeal is ongoing. You've got no choice. Coinbase, that civil case, they cited criminal cases, and when they cited these that the Supreme Court ruled on, they even cited notably double jeopardy cases that they say is mandatory. And they also said that it goes down to pretrial proceedings and trial proceedings, and Blossingame, it literally just reinforced this conclusion by reaffirming that presidential immunity is immunity from suit, not just immunity from liability, and we have to resolve that before any merits discovery. And Trump's defense is just on a tear here. They say, by the way, guess what? The prosecution has effectively conceded all three of these points. The prosecution has admitted that the stay is mandatory and applies in criminal cases. It cited a criminal case for the proposition that while a non-frivolous question of immunity is pending on appeal, the party asserting immunity cannot be forced to go to trial, citing United States versus other cases. Now they continue, they say, the criminal case that is cited by the prosecution holds that official claims of immunity and double jeopardy protect the appealing defendant from the burdens of litigation, not just the burdens of trial, right? Burdens of litigation, meaning you can't even charge him. And so these conclusions accord with the long-standing case law from the DC Circuit, that's you, Judge Chutkan, and other circuits holding that proceedings in a trial court should be stayed pending the appeals of the immunity and the double jeopardy claims. In immunity cases, likewise in DC, they've held, Chutkan, they said, quote, because an appeal properly pursued from a district court's order denying a claim of immunity divests the district court of control over aspects of the case that are on appeal, exclusive jurisdiction to resolve the threshold issue in this case vests in this court, and the district court may not proceed to trial until the appeal is resolved. Woo! Chutkan's not going to like that. That's from DC Circuit Court back in 1993, citing Griggs, a U.S. Supreme Court case. You know, she's going to do everything she can to avoid this, by the way. Now, in short, they say the Griggs principle already requires an automatic stay of Chutkan's proceedings that relate to any aspects of the case that are involved in the appeal. Now, if Trump's interlocutory is appealable, then they say that the district court loses its power here. And because President Trump's appeal considers whether the criminal case against him may proceed at all, the proceedings in this case are automatically stayed pending the outcome of that appeal. Wow. Now, the stay is warranted irrespective of the mandatory jurisdictional bar, saying in addition to this, Your Honor, this is mandatory, okay? But if you don't do it, the court should, in other words, right? It's mandatory, but here's why you should do it anyways. Like, you don't have a choice, but here's why it's the right decision. You should also stay all proceedings pending the appeal, given the well-established importance of resolving immunity at the earliest possible stage of the litigation. Though the Griggs principle reinforced that Coinbase is mandatory and it's jurisdictional, meaning you just lose it, it's also supported by strong policy considerations. So Chutkan, you should not feel bad about this, okay? We're taking this away from you, but don't be upset. Why? Because this is independently warranted. As the Supreme Court reasoned in Coinbase, they say from the judiciary's institutional perspective, allowing the case to proceed simultaneously, if you allow both things to happen, like it's going forward in the district court and it's going forward in the Court of Appeals, it creates the possibility that the district court is going to waste judicial resources, which could be devoted to other things. So you put it on pause at Chutkan's courtroom and you let it go up. That could then be devoted to other pressing or criminal or civil matters on a dispute that will ultimately be held to arbitration in any event, right? So we want efficiency. Same logic applies here, says Trump's defense. Allowing a case to proceed simultaneously in the district court and the Court of Appeals is going to waste resources, and it's going to be the worst possible outcome for all parties and the courts, especially if the Court of Appeals comes down down and says, yeah, he is immune, by the way. Then we just have a full trial for nothing? Now, they want the trial to go on because they need it to happen before the election, but there's no real judicial reason for that to happen. Just postpone the trial. Concerns regarding judicial resources and costs from continued litigation during the pendency of the appeal, including the financial cost, the reputational damage, the political cost to President Trump, they're all significant. Now, as the court noted last week, the court has not yet resolved the pending motions to dismiss on the statutory grounds. We're still waiting for that one. And we're still waiting for the selective and the vindictive prosecutions motions as well. And Trump has also filed motions to compel discovery. He also wants classified materials and says that the prosecution is going to argue that there are national security issues, and Trump needs to appeal those as well. And so Trump is also facing SIPA issues, fact-intensive SIPA proceedings. The court has also directed Trump to make intrusive disclosures about his defense. They also want defense exhibits. They want expert disclosures and all these things. And they also want to know whether we want to pursue the advice of counsel defense. So they're saying, Judge, you're making us do all of these things, but we don't even know if this case is yours because of presidential immunity and double jeopardy. The Court of Appeals have to resolve this. You want us to do all this garbage when we don't even know if this case is going forward? What gives? So it says the common practice of staying proceedings while such issues are on appeal reflects the standard practice. If the district court, if they could move forward with pretrial and trial proceedings while the appeal was ongoing, many of the benefits of the immunity would be lost. The whole point of immunity is that it is immune. So a right to interlocutory appeal of the immunity issue without an automatic stay of the district proceedings is therefore like a lock without a key, a bat without a ball, a computer without a keyboard. In other words, it's not especially sensible. And for these reasons and those cited above, a stay of the proceedings in this court is warranted pending the final resolution of President Trump's appeal. Saying in conclusion, the court should stay all further proceedings in this case pending the final resolution of President Trump's appeal and hold in abeyance all current deadlines until the motion is resolved. Hold in abeyance, okay? No more jury selection, no more pretrial deadlines, nothing. Saying finally, because the continuation of these proceedings in the absence of jurisdiction inflicts ongoing irreparable harm, Trump respectfully requests the court rule on this motion within 7 days. Pick up the pace. Now, if the court does not grant this motion and stay the proceedings, President Trump respectfully requests that this court enter a temporary administrative stay of proceedings while he pursues relief from the Court of Appeals. Good motion here. And Judge Chutkan is going to be fuming. She's fuming today. Counsel for President Trump conferred with counsel for Jack Smith, and they opposed the relief requested herein. And so no surprise there. Obviously, what's going to happen is Jack Smith is going to respond to this. Judge Chutkan is going to deny it in some way, shape, or form. They will appeal this, and then we'll see what the Court of Appeals does, because if they come back down and issue an administrative stay, that March trial might be not sticking around. And this is what we've been waiting for. We've been waiting for something to muck the gears up, because what Judge Chutkan has already done by trying to get this trial scheduled in March is basically insane, given the amount and volume of documents that exist in this case. So this is Jake Tapper, who's on CNN talking about a lot of these issues. And what we're going to do is see if we can increase the volume on the next segment and see if that will be better for us. But this is Jake Tapper on CNN with guess who? January 6th Kinzinger.
Continued support for the rioters of January 6th to help prove that he intended to inspire violence that day. How might this potentially bolster the prosecution's case, do you think?
Well, I'll leave it to prosecutors to discuss the rules of evidence, but the former president has made it clear that he stands with law violators, he stands with the rioters. He intended the riot to occur to keep in power. So his behavior before, during, and after the riot is all of one piece. He was for violence to overturn the government.
And former Congressman Kinzinger, what's your reaction? Do you think these statements shed light on Trump's intent before the riot, given that he's continuing to talk about these individuals being patriots and deserving pardons?
Yeah, completely. And, you know, all you have to do is see when he calls them political prisoners. Jake, what is it, like 3 weeks ago, he opened up a rally with these quote unquote political prisoners singing the national anthem, and everybody was saluting. You know, about the same time he called for the execution of General Milley. This is in contrast to, there is still like this flavor of people out there that believe that it was the FBI that did January 6th.
They were involved. They were there.
Sometimes it was Antifa.
They were there.
There was just basically January 6th was just some peaceful people that got wrapped up in everything.
They were there too.
Which goes to the question of, well, then why is the former president calling them heroes? You know, why is it that, you know, Speaker Johnson wants to protect their faces if it's the FBI and if it's Antifa? Well, it's obviously not. And it just goes to show the mentality of we've got to protect our tribe, our side, because this isn't about defending the Constitution anymore. It's about gaining power at all costs. And I think you're seeing that manifest now.
All right, so these people who are on one of the most illegally constituted committees in American history by their own rules, who just cobbled it together and created a fake tyrannical show trial, are now saying that Trump is an insurrectionist and tyrannical, and his behavior is antithetical to the American democracy. So that's what's happening out of the January 6th case, my friends. And of course, we will be here continuing to cover this one. We're going to be following this one quite closely. So thank you for subscribing. Thank you for hitting that like button. And thank you for going to robertgovea.com to sign up for our daily newsletter. We'll be looking forward to seeing you there and right back here on the next one.